I am totally addicted to the Pitt, and I can't wait for season 2. I just hope there is a season 2, because the estate of Michael Crichton filed a lawsuit against Warner Brothers, alleging that the TV show The Pitt is an unauthorized reboot of ER. Crichton's wife accuses producer John Wells and star Noah Wyle of being morally repugnant, peddling lies, and virtually erasing Crichton's historic contributions to TV and film. And Sherry Crichton saved the most vitriol for Wells, accusing him of being a plagiarist and betraying a 30-year friendship. But at the heart of the lawsuit is a frozen rights clause Crichton negotiated when he sold his original ER screenplay, which barred any future adaptations without his approval. The estate alleges that Wells, Wyle, and showrunner Scott Gamill deliberately concealed their reboot plans for 2 years as part of a plot to stop Crichton from getting his flowers. Now, obviously, there are going to be some similarities between shows that involve an emergency room, but the defendants argue that when an ER revival fell through, they created an entirely new show. So, did the defendants actually breach their contract, or is this just another case of Hollywood recycling ideas? And how much protection does copyright law really offer when it comes to stock settings like a hospital drama? Now, as you probably know, The Pitt is a medical drama series streaming on HBO, which I refuse to call Max, that offers a realistic portrayal of the challenges faced by healthcare workers in a modern-day Pittsburgh hospital. The show centers on Dr. Michael Robbie Rabinovich, played by Noah Wyle, a senior attending physician, grappling with the emotional aftermath of the COVID-19 pandemic. Each of the 15 episodes represents an hour of a single intense 15-hour shift in the emergency room, giving viewers a bird's-eye view of the chaotic environment of frontline medical care. The series has been praised for its authenticity and depth, earning a 96% rating on Rotten Tomatoes and securing a second season renewal. And our friend Dr. Mike called it the most realistic hospital drama ever. And I am honestly totally addicted to it. I don't even know why. I don't understand half of the things that are going on, but it's really compelling television. And I guess now that it's not HBO, it is television. But let's talk about the drama behind the drama. In 1974, author and screenwriter Michael Crichton wrote a screenplay entitled Emergency Ward, which was eventually adapted into the hit medical drama ER. Crichton assigned the copyright in his screenplay to Warner Brothers in 1994. And as the lawsuit explains, quote, more than 15 years later, Crichton worked with Steven Spielberg to develop his creation into what became one of the most successful television series of all time. Running for 15 seasons on NBC and earning Crichton an Emmy Award as ER's creator and producer, just one of the 23 Emmys that the series won from among the 124 for which it was nominated. And as part of that original contract, Crichton and Warner Brothers included a frozen rights provision, which stated that, quote, any and all sequels, remakes, spin-offs, and or derivative works shall be frozen with mutual agreement between Crichton and Warner Brothers being necessary in order to move forward in any of these categories. So stick a pin in that because it's a pivotal issue for the breach of contract claim. And as we'll discuss, there's a reason why this is largely a contract claim and not a copyright claim, although the two are intertwined. But the suit says that Crichton made billions of dollars for NBC and made a career for Noah Wyle, whose character was based on Crichton himself.
John Carter.
Yes, sir.
Peter Benton. You the surgical student?
Yep, third year.
And the complaint claims that Crichton resuscitated Wells' career after a plagiarism scandal. Oscar-winning director Barry Levinson and writer David Simon accused Wells of stealing entire passages from Simon's book, Homicide: A Year on the Killing Streets, and using them in the TV series Angel Street. Wells settled that claim, and the show was canceled after 4 episodes. Now, Crichton passed away in 2008, so his widow, Sherry, has control over his estate, and she has a reputation for pugnaciously guarding his copyrights. After Crichton died, the estate alleges that Warner Brothers started a, quote, disturbing pattern of failing to celebrate him, choosing instead to betray his trust and diminish, and ultimately erase, Crichton entirely from his creations. And the complaint outlines some of the estate's grievances, quote, the pattern began with Westworld, the HBO series based on the 1973 film of the same name that Crichton had created, written, and directed. In lieu of the created by credit that Crichton deserved, the studio relegated him to a based upon credit buried deep in the end credits. But that indignity pales in comparison to what WB-TV and its cohorts are now attempting in connection with ER. Now, as we've covered many times on this channel, allegations and a complaint are a one-sided story, so you may want to take some of these allegations with a grain of salt. They are a story told by one party to be persuasive. These slights apparently continued when producers sought to reboot ER. Sherry Crichton said that Wells called her on Thanksgiving Day 2022 after not speaking with her for years. Wells wanted to reboot ER, and he informed her that there would be a big press release on deadline announcing its return in a matter of days. Crichton said that Wells lied to her about how the series had been planned, claiming it had come together virtually overnight, and she says this was treachery because Wells and Wyle had been planning the reboot since 2020. She alleges that Wells knew about the frozen rights and wanted to shut her out of the deal. WB-TV called Sherry in early December and offered her a deal for the ER reboot. And at the time, Warner's allegedly said it would, quote, respect the Crichton estate's rights of approval to move forward with any subsequent productions. Now, the estate argues that this meant Warner's intended to respect his frozen rights, When the estate contacted WB-TV to follow up, the studio balked at giving Crichton the created by credit, and the negotiations stalled. Once Sherry Crichton asserted the frozen rights, she says Wiley and Wells reached out to her in, quote, a shameless attempt to pull at her heartstrings. For example, in a January 27, 2023 email to Sherry, Wiley expressed that he was appalled at the examples of disrespect shown you, Michael, and the estate, including in connection with Westworld. Wiley told Sherry that I admire, respect, and back your fight to protect Crichton's legacy and authorship, and assured her that was my sole intention here, as my gratitude to Michael will be everlasting. Sherry sent Wiley an email thanking him for reaching out, but told him, ultimately, all this rests with Warner Brothers. Wells was apparently next up, telling Sherry that I don't know anything about Michael's name being virtually erased from Westworld, and I think it was despicable. However, Sherry notes that Wells could not keep his own ego in check and bragged to Sherry with respect to the money Crichton had made from ER. Frankly, I made that money for him. Now that did not go over well with Sherry, who told Wells the proposal Warner Brothers made was below market and thus unacceptable. It also involved troubling self-dealing. Later, Wiley apparently emailed Sherry a chronology of events, which backfired because it fueled the estate's claims that the reboot had been in the works for 2 years before anyone notified Sherry. Quote, Wiley had first reached out to Wells all the way back in February 2020 with the idea for a limited series that would pick up where ER had left off. Like the original series, the reboot would show the continuing collapse of urban hospital care as the COVID-19 pandemic, drug abuse, and chronic homelessness eroded the public health system. Wiley would reprise his role as a now seasoned physician, and the show would follow him through a 14-hour shift, during which he overcomes disillusionment with the system and recommits to his profession. The following year, Gamel reached out to Wiley with his own idea for a Carter-centric reboot, and they continued their discussion with Wells, culminating in an expression of interest from NBCU in July 2022. After that, apparently the estate still reached a tentative deal with Wells' production company. Wells agreed to the created by credit for Crichton before the Writers Guild, backed by a $5 million personal guarantee from Wells in the event those efforts were unsuccessful. However, apparently when WB-TV got back in the mix, the company allegedly yanked Wells' $5 million personal guarantee and the credit the estate wanted. That's when the estate invoked the frozen rights. But this time, Wiley, Wells, and WB-TV claimed that interest had plummeted in the ER reboot, and they moved on to create the Pitt. So the estate sued for breach of contract, interference with contractual relations, and breach of the covenants of good faith and fair dealing. Now, if you get in a fight with a big Hollywood studio, you're gonna want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So let's talk about the legal aspects of this whole case. As we've talked about many times on this channel, copyright in US law is a form of legal protection granted to the creators of original works of authorship, including literary, artistic, musical, and audiovisual works. And under the Copyright Act, copyright gives the creator exclusive rights to reproduce, distribute, perform, display, and create derivative works based on their original work. Now, these rights generally last for the author's lifetime, plus 70 years. But one of the major limitations on copyright is that copyright does not protect ideas, only their specific expression. Now, important here, derivative works are new creations based on a pre-existing copyrighted work, such as sequels, spin-offs, remakes, or adaptations in a different media, such as turning a screenplay into a film or a TV show into a video game. So for example, talking about Michael Crichton, Steven Spielberg had to get the rights to Jurassic Park from Michael Crichton in order to make a movie based on the novel Jurassic Park. But if you want to make an original movie that's a spy thriller based on a secret agent, you can absolutely do so, but if you want to make a sequel to James Bond, then that would be considered a derivative work, and you would need to get permission. But frozen rights clauses in copyright agreements are contractual provisions that limit or restrict a copyright holder's ability to exploit certain rights, usually derivative works, without the consent of the original creator. In the context of a frozen rights clause, derivative works are often the main focus of restrictions because they represent the most valuable long-term commercial opportunities. Without a frozen rights provision, a studio is free to develop derivative works without the original creator's input or approval. However, when such a clause is in place, the creator and their heirs retain control over whether and how derivative works are made. Derivative works can include sequels, remakes, spin-offs, reboots, merchandising, video game adaptations, amusement parks. Basically, every iteration of Harry Potter, for example, is a derivative from the original novels. And the Crichton dispute is a great example of how much harder it is for a studio or rights holder to make a derivative work when the creator has frozen rights. Not every writer is in a position to demand control over derivative rights, and studios generally only cede these rights to writers or creators with significant bargaining power. So when Crichton sold the rights to Westworld in the 70s, he didn't have much bargaining power. He was a new author. But by 1994, he was a highly popular author, and NBC really wanted the screenplay. So Crichton had leverage and he knew what to do with it. But there's another angle to this dispute. The frozen rights only kick in if there is an actual derivative work. And the defendants argue that the Pitt is not a derivative work of ER at all. So the defendants responded contending that, quote, the lawsuit is an effort to prohibit lifelong artists, the acclaimed writers, producers, and actor named as defendants in this action from publishing their work. And as such, they filed a motion alleging the case should be dismissed because it was a violation of California's anti-SLAPP law. And as we've talked about many times, SLAPP lawsuit, a strategic lawsuit against public participation, is designed to silence or punish people for exercising their free speech or petition rights. And anti-SLAPP laws protect individuals from these abusive lawsuits. And in California, which has one of the nation's strongest anti-SLAPP laws, when a defendant believes they are being sued for protected speech or petition activity, they can file an anti-SLAPP motion and have their case dismissed early and recover attorney's fees. And the defendants in this case argue that the Crichton estate filed the lawsuit in order to stop their creative work from ever seeing the light of day. The defendants acknowledge that Crichton's contract with Warner's, quote, regarding ER says the parties cannot make derivative works of ER without his consent. In 2022, some of the defendants approached Ms. Crichton about the possibility of making a reboot of ER. But Ms. Crichton rejected multiple proposals on extremely generous terms, and when it became clear that a reasonable deal was impossible, defendants decided to move on from the potential project. The defendants accused Sherry Crichton of demanding many millions of dollars, quote, well above industry standard rates, and more than WB-TV was willing or able to pay for a series in its first year. After Sherry allegedly stuck to demands that the studio called exorbitant, the defendants say that they walked away from the series, and Scott, quote, Gamel then worked to create a new show. And here they are laying the groundwork to claim that even though they originally wanted to do an ER reboot, that the second show was something entirely different. Quote, still interested in returning to the medical genre, but unburdened by the constraints of an ER reboot, he felt he could do something new. His excitement about creating something distinct from ER colored nearly every decision made in developing The Pitt. And defendants say the new script dropped all the elements of the old ER TV show. They said, quote, The Pitt does not align with any of these definitions as it does not share plot points, characters, or settings with ER. Therefore, it cannot be classified as a sequel, remake, or spin-off. Quote, The Pitt is not a derivative work, it is a new show with different names, iconography, plot lines, characters, locations, pacing. That both shows are medical dramas set in an emergency room and some of the same parties worked on them is insufficient as a matter of law to make The Pitt derivative of ER. Similarities are unprotectable ideas or scenes of fair. And I think this is the heart of what makes this particular case so fascinating. The scenes of fair doctrine is a copyright principle that excludes certain elements of creative works from protection because they are standard, inevitable, or dictated by the subject matter. The term comes from the French meaning scenes that must be done. And under this doctrine, courts recognize that some elements in a work are so commonplace or necessary for a particular genre or theme that they can't be copyrighted. These elements include stock characters like a hard-boiled detective in a noir story, common settings like a saloon in a western, standard tropes like a hacker using a computer screen covered in code, and predictable sequences of events such as a police officer reading a suspect Miranda rights in a TV crime drama. And scenes of fair is really important because it prevents copyright holders from monopolizing basic building blocks of storytelling. Now, to be liable for copyright infringement, the courts look to whether two works are, quote, substantially similar.
No, that's not good. Let's go again. 300?
Substantial similarity is a term of art. You can't just say, oh, these two things are substantially similar. There's a whole framework to determine that standard.
Pulse clear.
All compressions?
And courts employ a two-part framework to assess substantial similarity between works. There's the extrinsic and intrinsic tests. Now, the extrinsic test is an objective analysis that dissects specific expressive elements such as plot, themes, dialogue, mood, setting, pace, characters, and sequence of events. It focuses solely on protectable components, excluding ideas, historical facts, or genre conventions. Now, this is probably hard to visualize for non-copyright people, but when you're making comparison between two works of art, you have to filter out and not take into consideration the unprotectable elements. So for example, if someone claimed that one movie was a ripoff of James Bond, and you were comparing the two movies, you probably wouldn't be able to use the mere fact that both main characters were secret agents, or used a handgun with a silencer on it. However, you probably would be able to use the fact that both characters, if this was the case, ordered a martini shaken, not stirred. The former are genre conventions or scenes of fair that are so ubiquitous that it would be unfair to make them protectable elements. But the latter is specific and creative enough expression that probably would be evidence in a copyright infringement case. So if a plaintiff's work fails to meet the extrinsic test, the case must be dismissed without proceeding to the intrinsic test. Now, the intrinsic test, on the other hand, is a subjective evaluation that considers whether an ordinary reasonable audience would perceive the total concept and feel of the two works as substantially similar. And that assessment is typically reserved for the jury. Now, the war over the film The Last Samurai, which starred Tom Cruise, is probably instructive here. In that case, screenwriters Aaron and Matthew Benet alleged that the Warner Brothers film The Last Samurai infringed upon their screenplay of the same name. Applying the extrinsic test, the Ninth Circuit Court determined that the similarities between the two works were primarily based on unprotectable elements. The court said, quote, "A number of similarities between the works arise out of the fact that both works are based on the same historical events, take place at the same time and in the same country, and share similar themes. These similarities are largely between unprotected elements, historical facts, characteristics that flow naturally from their shared premise, and scenes affaire." The Benets contended that they had submitted their screenplay to Warner's, and therefore the studio must have reviewed it and incorporated elements of the screenplay into the film. And you can imagine the screenwriters coming to the conclusion that a studio committed copyright infringement when they submitted a screenplay to that studio about an American who became a samurai in feudal Japan, and the studio released a movie about an American that became a samurai in feudal Japan. But the ruling emphasized that mere access to a work does not substantiate claims of unauthorized use. There must be clear proof of substantial similarities in protectable elements between the two works. The court concluded that the works were not substantially similar in their protectable aspects and upheld the summary judgment in favor of Warner Brothers. But all was not lost for the Benet screenwriters. While they lost their copyright claim, they did eventually prevail on some of their contract claims against the studio. And here, in the case of ER versus The Pitt, the plaintiffs and defendants have very different viewpoints about whether The Pitt is a knockoff of ER. The estate says that, quote, "The Pitt is ER. It's not like ER. It's not kind of ER. It's not sort of ER. It is ER, complete with the same executive producer, writer, star, production company, studio, and network as the planned ER reboot. No one has been fooled. The Hollywood Reporter recognized the reboot, now named The Pitt, for what it actually is, ER 2.0. And the defendants could not disagree more. Quote, "Once you look past the generic elements of the genre, The Pitt is entirely different from ER, involving different names and iconography, different plots, different characters, including those played by Wiley, whose character in ER was a green resident, with different themes, a different setting, a different pace, and a different approach to music and lighting. ER was also bound by network restrictions on language and nudity. The Pitt is a streaming show uninhibited by such restrictions. But generally sharing a plot and themes doesn't make a creative work derivative.
You think you know what you're doing? Believe me, you don't."
But the estate claims that the pilot episodes of both shows are strikingly similar. Quote, "Both pilots begin in the early morning and take place over the course of a single day. Both series use act breaks, commonly referred to as commercial breaks, which in the case of The Pitt is highly unusual for a series airing on premium cable or a streaming platform that does not air commercials. The main character's co-worker, friend in both series is a roguish bad boy. Both pilots introduce characters who are students interns on their first day at the hospital and are not prepared for what they will experience.
Med student down.
Welcome to the Pit. Let's go save some lives.
Both pilots have hospital staff members with suicidal tendencies.
Excuse me, she's my patient. Miss Carlton, please, please.
What are you doing here? Working. And if you jump on my shift, that's just rude, man.
And both pilots feature patients who are regulars in the emergency room to the point where the staff know their names. And this is a great example of how in copyright cases, often the war is won or lost by the level of abstraction that you convince the court to use. Do you really drill down into the very minute details, or do you take a more 10,000-foot view to blend commonalities together? Now, clearly, some of these similarities stem from the fact that these are common tropes. Harried medical students, roguish doctors, and patients who are frequent flyers. These might be tropes because they also might be common experiences in real-life hospital settings. But certainly at a higher level of abstraction, the concept of a drama set in an urban hospital is a general idea that's not protected by copyright law. And as Wells points out in a declaration in the case, many shows and TV take place in similar settings like City Hospital, St. Elsewhere, ER, Casualty, Chicago Med, Dr. Kildare, Grey's Anatomy, New Amsterdam, and The Good Doctor. And the defendants argue that while the pilots share some similarities, the overall structure of the two series is different. After the pilot, ER followed a traditional case of the week format. The Pit follows the doctors, nurses, and patients over the course of a single 15-hour shift, more like the TV show 24. Though the estate alleges that the concept of the ER reboot included this element, the single shift. And the most fascinating part of this case might have to do with what we make of Noah Wiley and his character. According to the estate, quote, Wiley's character is Dr. John Carter from ER in all but name, only 30 years later and imbued with the experience and lessons learned during the 15-year run of the original series. Now, a lot of people probably can't look at Wiley playing an ER doctor without thinking about the Dr. John Carter character, who ended his time on that show as a disillusioned doctor. And he's somewhat delusioned with medicine in the Pit as well, although that's arguable. But it also probably isn't determinative. As defendants point out, Noah Wiley himself is not protectable. Quote, that Wiley is involved in both shows is irrelevant in the derivative analysis because the identity of the actors in a show is not protected by copyright. Actors often portray characters with the same profession. And they point out that Mark Harmon playing a doctor in St. Elsewhere and Chicago Hope. Omar Epps played a doctor in ER and House. Now the case is going forward. The Los Angeles Superior Court denied the defendant's anti-SLAPP motion. And in doing so, it first ruled that defendants had established that the claims are premised on the creation of a television show, which is a constitutionally protected exercise of free speech. Consequently, the burden shifted to the estate to establish a probability of success on the merits of its claims, all of which, quote, rely on the issue of whether the Pit is a derivative work or otherwise infringes the copyright of ER. And pointing to the timeline of the planned ER reboot, including failed negotiations between the parties, followed by the creation of the Pit, the court concluded that the estate had met its burden to demonstrate that its claims have at least minimal merit. The court also cited a declaration by the drafter of the 1994 agreement as sufficient to challenge the defendant's interpretation of the contractual definition of derivative works. And finally, the court held that it could not determine at this early stage of the litigation the key question of whether the Pit was derivative of ER or not. So it'll be interesting to see what happens here. There are good arguments on both sides. My take is that it seems clear the parties tried to do an actual ER reboot. I don't think anyone denies that. And if they had gone forward with that, defendants would have needed the Crichton State's permission to do so. They obviously tried to do that and couldn't finalize the deal. And once that happened, the creators had the right to move on and do another hospital show, as long as it wasn't derivative of ER. The fact that they tried and failed to do an ER reboot doesn't necessarily mean that the creative team can't ever set a show in an emergency room. And they may have been influenced by ER. It would be hard not to be when Wiley and Wells are involved. But what about other influences? The show was clearly influenced by 24, but it's not the same as that show, and the estate might have gotten over its skis and let their obsession with how much credit Crichton wasn't getting get in the way of a good business deal that would have made them money. But one thing about the Pit that strikes especially close to home for me is Dr. Robbie's boss forcing him into impromptu administration meetings while he's frantically trying to save lives and time is of the essence. Because when you work for a big firm, this happens all the time, often with the same amount of blood on the floor. Now, I'm joking, of course, about the blood. Or am I? Yeah, sorry, I've been watching a lot of Abolish Everything lately, and honestly, it hits really close to home right now.
We need to abolish meetings! We all want to do other stuff!
As you might know, Abolish Everything is an original comedy show that I really love where comedians argue to abolish everyday aspects of society against a panel who are hell-bent on preserving the status quo. And at the end of every episode, the audience decides who's right. But the only place where you can watch Abolish Everything is on Nebula, the streaming site that me and my fellow creators created from the ground up. And if you click on the link today, you can get 40% off the annual subscription. That's only $3 a month. And Nebula is the only place where you can watch exclusive LegalEagle videos like our analysis of the thin legal line standing between RFK Jr. and the national ban on vaccines, or you can check out our exclusive companion videos like the one for our recent video about unhinged judges that was too spicy for YouTube. And in fact, there's tons of exclusive LegalEagle content on Nebula, including our feature-length documentary, Bad Law, Words Good. And of course, on Nebula, you can watch all LegalEagle videos ad-free and early because our videos always go up on Nebula first. And for a limited time, you can get an exclusive lifetime membership by using my link. You can buy once for $300 and then never again. This is honestly the greatest deal of all. And when you get Nebula for life, it means we're in this together forever ad-free. Nebula also includes tons of exclusive videos from over 200 of your other favorite creators like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and the roster grows every month. So sign up for Nebula today, watch some episodes of Abolish Everything, and then click on this link over here for more LegalEagle, or I'll see you in court.